Immigration policy changes every day. Careers, businesses, and families are all at risk. You need to stay informed. We can help. Welcome to this week's episode of the Immigration Podcast.
I am not Donald Trump, and I do not approve of the Immigration Podcast.
All right, welcome to episode 8 of the Immigration Podcast. My name is Rob Ratliff. I'm an immigration attorney in Cleveland, Ohio, and our other co-hosts today are...
Nor, go ahead.
Noor Shamas. I'm an immigration attorney in Cleveland also.
And my name is Susan Hiller, and I'm a former DHS ICE attorney, federal prosecutor, and I am at Hiller Law Group in South Carolina, but in the North Carolina, Charlotte area.
Excellent. All right, so what's going on in the immigration world these days? Susan, you were fired up about BIA yesterday.
Oh, yeah. So I actually filed a lawsuit, a mandamus, against Cersei Owens, one of my former supervisors, actually, too.
Is she still employed?
Yeah. She's very Trumpy. Yeah. Absolutely.
Well, they appointed a new person, so I didn't know.
Oh, maybe not. That's right. I saw that, but I don't know about, well, I hope not, because I'm about to file a bunch of bar complaints. We'll get into that once I find out who actually wrote the decision, but the board member for sure, because he signed off on it. So without further ado, was Cersei Owens, though, that I sued, and a mandamus in federal district court. Basically, there were several motions that I filed on a case that was on appeal to the Board of Immigration Appeals. And the person who filed the appeal is a immigration attorney named Benjamin Schneider. And the appeal was on an I-751 joint petition. You guys know the difference between a joint petition and a waiver, right?
Correct.
Okay. So that was the appeal. There might have been, but that was the appeal. All right, let me get into the other part of it. So that appeal has been pending since 2022. There's been no transcript. This is not what I filed the actual mandamus on. Not on the appeal, because I actually have another reason for it to be terminated. But I filed actually, let me go back to the appeal.
That was one of the things. She'll get back in here. But that was one of the things that
can you guys still
I was
see
shocked
me? Hear
about
me?
when I first got appointed as a judge was the number of judges and that talked about it, and the number of times it happened that practitioners were filing bar complaints against immigration judges for decisions and things that would happen in court, just procedural issues and things of that nature. And I don't know, it was something that I don't think it ever occurred to me to file a bar complaint against the immigration judge.
I've never thought about that.
But it's apparently, especially in some jurisdictions, much, much more common than, I don't think I've seen it happen in Cleveland yet, but I'm sure, you wouldn't necessarily know as well.
I mean, the only thing I know is there wasn't a bar complaint, but there was a complaint to EOIR that was filed against Judge Riley at the time in 2021.
Yeah.
And then they compelled her to do additional training. So they took all the cases she had off her calendar and then had her do training for a while, and then she came back on. She seemed fine afterwards. So I don't know if the training helped or the fact that she got complaints helped. But I personally have never seen a bar complaint against the immigration judge.
Yeah, I've seen and heard of, a number of judges that, they go back through the training and stuff like that, but I don't think that happens now. I think you just get fired. But,
yeah. Well, now you get fired for different reasons, though.
Yeah. Yeah. And I think some of them are getting fired for this case management processes that they've published, getting cases done in a certain period of time. And I think they're really looking at that.
But it almost seems like they haven't had enough time to really assess. I think part of it was they just wanted to get rid of judges to supposedly cut costs.
Yeah.
I think that was initially what they did because they couldn't have at that time had enough time to assess which immigration judge is getting cases done at the rate that they want. But I think because it was easier to fire those that had not established tenure, or were still within their probationary period. I think they were trying to fire those judges first. But now, because I feel like they have contradictory goals. One was they wanted to finish cases as quickly as possible, but on the other hand, they wanted to fire judges, which would create a bigger backlog in immigration courts, which would make cases last longer.
Yeah, and I was reading through some of the policy memos earlier, and one referenced even they want the oral decisions done and in the same hearing as the all at one time. They're rescheduled for an oral decision, which is really, I mean, that's pretty difficult. You got a 2-hour hearing, you got to take all the testimony and give the oral decision.
That's really, really difficult to do. In fact, in a lot of the cases I've done, when it's a full hearing, which is 4 hours or more, they still don't have enough time to get an oral decision done right after the hearing. And we've both had cases that have to have multiple IHs. So it's not out of the ordinary to do that.
Yeah, and I think those 2-hour trial blocks are almost counterproductive because you can't get everything done, and then combine that with the fact that DHS now will stipulate or agree to almost nothing.
Right.
So you can't reach any factual stipulations, almost never, and everything's got to be contested. And it's one thing if it's just a very basic asylum recent entry kind of case, but when you've got complicated cancellation, or as Susan was just talking about, 751s, whether joint or self-petitioning, those can get really fact intensive and document intensive. And
well, I've had multiple cases where direct testimony, we didn't have enough to finish direct examination in the 2-hour time slot, so it's almost impossible to finish a case in 2 hours, unless it's one of those really, really, really straightforward cases. You can probably do like some adjustment cases in 2 hours. Some of the weak.
Yeah. Look who is here, Mr. Soleil. and I think Susan Hiller is logging back in, so we'll see her face here in a moment. How's things in Syracuse? But that's regardless of how long you've been here.
I don't know about how long it might be still within 2 years, but from what I known is they're going to detain everyone. Now, they didn't detain one of my clients that was within the 2 years, but that was only because he had a U.S. citizen child. So they treated it as a family unit. And they said at this time, they just don't want to, they don't have the family unit space. And they just, I guess, kind of, there's an interesting situation where can you really keep a baby U.S. citizen in a detention center? So, but that's something to watch out for. Now, tomorrow I have a really hard one. It's an unexecuted order of removal for order of supervision with order of supervision, but she's a military member. She's got a pending motion to reopen to apply for PIP. I'm actually going to test it out and see if, because, again, I think we still respect our armed services and our military, and, you have one child, all the children are U.S. citizens, and one of the child is, right now currently deployed. I'm going to see if I'll say, hey, why don't we skip the process of the motion reopen in front of the BIA? Just parole her. She's going to be eligible for PIP, but if you parole her, we can skip the entire process.
Yeah,
you just need a parole for 1 day.
I had actually a nice check-in, which was, it really surprised me. We actually thought that he would be detained because he had a prior executed order of removal. He re-entered illegally. I think we just did a reasonable fear request, and I went to the ICE appointment with him. And they just came out, verified his address, made sure he was still working at the same place, and then just let him go.
You had a non-detained reasonable fear case?
It was well, they haven't scheduled him. We made a request, but he was non-detained. Yeah,
That's unusual.
I know. And I thought, actually, when I was going there, I was thinking, yeah, he's probably gonna get detained. Kind of getting him ready for it.
Yeah.
But
I did. We had a detained reasonable fear 2 weeks ago,
Mhm.
and the judge affirmed the asylum officer's reasonable fear. So he was put in. He was, had the order of removal. Last week, he's calling me because he wants to leave. Doesn't need to stay detained any longer than necessary. They put him back on the calendar and issued an NTA.
well, that is strange.
So, we're going to file for bond, and he's got multiple potential avenues for relief if they're going to put him in just regular proceedings. So,
Wow. You're muted, Anas.
Right. But I think there's such a mass overflow. I mean, like now it's hard to even get an immigration court date.
Mhm.
It's just such a mass overflow, max capacity. I think the initial part was just to kind of like a shock and awe, just maybe to get a lot of self deportations and voluntary departures. And
Right.
then I think eventually now is the situation where I think there's a lot of pushback and saying, there's a lot of people here with eligible relief under the INA. You want maximal enforcement under the INA, but as long as you qualify under the law, if there's a waiver or relief or something that's really viable, let's focus our priorities. So I think eventually it's going to turn into a priorities memo without one issue.
yeah, and they're going to have difficulty maintaining that 60-day calendar for detained cases that have any kind of viable forms of relief, because you can't present. We were just talking about how long it takes to do a 42B or cancellation or removal case or something like that. You can't do it in a 2-hour block, and to have 2 or 3 2-hour blocks scheduled in a 60-day period, it's not possible.
Exactly. And now the fees are so expensive too. There's a lot of different avenues that everything, it's an interesting ethical issue where, originally when cancellation removal was like $100, asylum is free, and adjustment of status is, just the regular price without the extra additional fee. Excuse me, I don't want to price it. I meant fee. The regular fee. You think from a point of not wanting to get a Lazada claim or something, you want to try every form of relief, even if one is probably like a low percentage of help. But now we have a situation where clients can't really afford it. And if they're not detained, the fee waiver says that if you have a private attorney, the BIA has said if you have a private attorney and you're not detained, you're kind of presumed to be able to afford the fee. It's going to be interesting how that dynamic works, and the necessary thing to put in writing, informed consent, to say, hey, I advise you, we got to do all this stuff. But, if you choose that, given the low viability and the cost, you don't want to do a certain application. I feel like we need to get that informed consents now, because it's just not viable to make, when a cancellation removal application costs thousands and an adjustment costs thousands, and it's a really tight bind they put us in.
Yeah, and it's similar in doing like federal appellate work where you have the page limitations and things like that. You have to have the conversation with your client. How much space do you want to spend on this issue that's that we're just hoping something happens.
Right.
And you can't you have to have that discussion with the clients, and a lot of people aren't going to understand that, why aren't we raising everything?
Yeah.
It's difficult to explain.
But I've seen it in multiple places in different courts. They're willing to do these pre-hearing conferences now where, you submit the application, everything's reviewed. And I got an interesting order from a judge because we had DHS agree to to check our 237A1H waiver first.
Mhm.
And the judge now says in their order, I'm just going to bring it up. It's a really interesting order, where there's certain things, they even want us to have the stipulations ready by the hearing.
Has
So,
DHS indicated a willingness to stipulate, though?
but here's the thing: is DHS was willing to, they initiated the at our request, rather than go through a long, protracted removability hearings and so on, because again, they're very overwhelmed too. They said, hey, you know what? We'll agree to see your 237A1H waiver. Hey, Susan. We'll agree to hear your
I think
237A1H waiver, and you guys both discuss it, and the judge is going to resolve the disputes in a manner that's timely, impartial, and consistent with the act. So basically what it is the respondent doesn't have to appear. Okay, that's optional. The parties are encouraged to conference between each other and make good faith to ascertain any opposing position of the party. And if anyone's going to file a motion after this is scheduled, you got to discuss it with DHS or the respondents council. They got to discuss everything. So it's actually, it's pretty interesting. I mean, the judge order, I wish I could share my screen. They, they said you got to be prepared if the DHS is going to dismiss proceedings or stipulate to relief. They need to be prepared to move or agree at the pre-hearing conference. So the judge is ordering them that if, it's not a situation where it's just, hey, the respondents council saying, oh, I want this, and DHS counsel not prepared and says, I got to get back to you. No, they have to have a position, whether they're going to dismiss, admin close, or stipulate at the hearing. That's an order by the judge.
Be interesting to see if DHS complies.
DHS would, they really need to, because another part of the order says that both counsels for the parties must have the authority to stipulate about all matters, including resolution of the proceedings. So whoever shows up to the hearing conference cannot say, I need to check with my supervisor, or I can't say I got to check with the partner. No, anybody per the order has to show up with the authority. So that's a great situation, because, you're representing to the court per the order. When you show up to the hearing conference, I can settle this without additional authority.
Can I weigh in on that as a former?
Yeah, because I was just going to ask you about that, because DHS very often DHS will say things like, well, Judge, I don't really care what you say. We're a different branch of the government.
Yeah. And I did think that that's what was going on. What I heard from former immigration judge George Pappas was that they were being told as immigration judges they had to defer to DHS. Basically, DHS was in charge of the court. I mean, it's, this is this administration. It's not actually correct, but they were trying to take away the judge's judicial independence, is the way I understood it. Now, that was Boston. I don't know what's going on in different places, but there were several different people that were on. I don't know if you guys got to see this. It was on CBS, PBS, with the 4 judges. One of them was, I believe, the assistant chief immigration judge out of Chicago, or
Yeah, she was the former assistant chief immigration judge.
Well, she was right.
The one that was fired.
She was fired. Right. These are all fired judges, but they were fired because political firing. It wasn't really based on, George Pappas actually was blowing the whistle before that to Senator Elizabeth Warren.
That was Jennifer Payton, I believe.
Yeah.
Yeah.
But they were trying to do their job correctly and follow their oath to the Constitution, and not an oath to an administration when they're telling them to do things that are not constitutional. Okay. As an ICE attorney, though, I find that depending on which office you're in, that's going to be very burdensome for DHS counsel, which we're called, but we're really ICE attorneys. But DHA's counsel because you got to go to your supervisor. Supervisor has to be available, and the supervisor has to have a decision. And a lot of times, these supervisors have to defer to the chief counsel. And for Charlotte, chief counsel's in Atlanta, and he also controls Stewart. And he was never good actually at being able to get back on PD motions. We were supposed to get them back within 30 days, like a decision. And he was constantly going past that. He just couldn't keep up with the amount of work. And he also wanted to find that he liked to deny things. So, and he didn't like giving authority to even people who were the most senior attorneys, like myself and James Jones at that time, because he just wanted to have all the authority. So for certain offices, I think it's going to be hard for them to get back to us quickly. And I also,
Robert, do you remember?
as a senior attorney, I hate the idea of having to go and do a mother may I to somebody who has less experience than me, who is my supervisor.
Well, yeah,
Robert, do you
I
remember
understand.
even under the previous administration in Atlanta, they kept sending those notices of non-appearance, and there was I felt like a bit of a tussle between the courts, the immigration courts, and DHS, because DHS
That's
felt like,
fine.
or that office at least, felt like they didn't have the manpower to handle that many cases, and so they would just not appear to these
That
individuals.
wasn't it. That's not it. I mean, there was a lack of manpower at times because there's a lot of turnover in the Atlanta office because there are deputies, like Cersei Owens was a deputy there. So was an Emily Reese, and they treat the line attorneys horribly. I mean, it is, I'm going to say this because the truth is everybody knows like what those two individuals did to abuse the line attorneys is well known, but you know, they got away with it. I don't know why, except for Alfie Owens also was, their supervisor who picked them. And then Ryan Masunu was handpicked by Ken Badia, who was in headquarters at the time. They used to work together in New York, and he picked him because he denies everything. You have this person who also smiles to your face, but he's not kind behind the scenes. And he backstabs people. And he used Emily and Corey White and Charlotte, and he used Cersei Owens, but she got pulled up during Trump 1.0. So really, Cersei was used by Alfie.
And I also saying if the immigration judge has given an order to DHS, I mean, what was DHS's position on whether or not they had to follow the judge's order?
Yeah. Oh, 1 second though. I want to clarify. Can I clarify one thing? I think what the purpose of this is, and when giving the order, okay, there's sufficient lead time. So, for instance, I got the order this month. You're not going to have a hearing till April. So, what we're trying to do here is, in a strategical way, and you know what, with OPLA, especially a lot of the OPLA attorneys that do, they're really great people. I mean, they're trying to do their jobs. And sometimes you can find creative solutions. You find great creative solutions because, look, you don't want to litigate every case. So this is for cases that, look, it's going to be a really hard contested removability hearing, right? And there's clear eligible relief. So what we're envisioning here is, okay, I'm going to submit the application to you. You're going to review it. And we're going to submit it to the court in my position statement. We're going to review everything, okay, ahead of time. And then you're going to kind of get the feel of the case. And when we go to the court, I think the judges, of course, they're not going to be able to rule, they can't say, oh, you have to do this or not. But it does give a situation to be like, judge, here's our position. Here's the government's position. Here are the facts. You see the application and everything. Rather than go through an individual hearing, what do you think? Do you think there's discretionary issues? Do you think this is something that is grantable or viable? Like, am I just in left field, or is there some common ground here? And I think it's a good collaborative way to deal with some of the cases so we can free up the docket, We can, get everything out. If it's a clear-cut case, I think it also allows OPLA a little bit of time too, is instead of having to be totally prepared for an individual hearing and have to fight over it, or a removability hearing or something, you get a collaborative method where you sit down with the judge and you get real life feedback from the judge. Because I would love to hear what you think, Susan, but if the judge is saying, look, I understand, because remember, in our situation, we will concede removability if we get our waiver. The government proves its burden, it did its job. But even if the government objects, the judge still can grant a 237A1H waiver and grant the discretionary relief. So in this situation, it's not like OPLA is taking too much of a stand or something, or stipulating. Even if they might just stipulate that, hey, we have no position, whatever your honor thinks, go ahead. And the judge might be like, look, I'm going to grant this. I'd rather you don't have to take a position, don't stipulate, but I'll just grant. And, so there's a lot of ways I think this is selectively used as a way to, at the end of the day, we have great working relationships with each other, like Rob. And also, if you work with a lot of the OPLA attorneys for a long time under different administrations, right? So you still have that working relationship. There are certain cases that I think even under this administration, you can work out.
I think that is awesome, because it reminds me of second term of Obama. I worked under, when did I think I started under Clinton, and then we had Bush again, right? And then we had Obama, Trump, Biden, Trump. So I've worked under all those presidents. I love that. That's what they did under Obama. I think his second term is when I was with ICE. I was with ICE then too, and under Biden, I was with ICE. But they did that, and it was excellent. But that was a different administration. So what I love is that your court and I know you call them OPLA attorneys because maybe that's what they like to be called now. But whatever they want to be called, OPLA, the way we in the field pronounce it. But I love the fact that your attorneys are willing to work with you and that the court is willing to work with you. It just seems like democracy. And it might be the type of cases you're doing too. 237A1H is something that really should be granted a lot of times. And it's just like cancellation 42A. That one, as long as you have a good case, it should be granted. It's a one-time get-out-of-jail-free card. What about asylum, though, Annis? Like, would they do something like that with asylum?
I don't think it's too appropriate for asylum because they really want to see the credibility. I don't know. What do you think, Nora and Rob? I think asylum's a little different. Maybe, maybe not, depending on how severity and if it's cumulative or not. But we're talking about like adjustment cases, CAA cases where, I'm scared. Not scared, but I've taken the position that I'm not terminating my CAA cases anymore. I put them in admin closure for a while, and then maybe we get a dismissal later on so they don't get detained. But if the judge had jurisdiction over the Cuban Adjustment Act, if for some reason they got paroled afterwards or so on, that might be a situation where you could stipulate and get faster relief. What in essence we got to do is, as the respondent's attorney, we just basically got to do all the homework for the government attorney, for the judge, and for us. So it's a lot of work, but we do all the homework. We get everything together. We put it together early. We get this opportunity before an individual hearing to kind of get a sense of everybody here. And I feel like if you do your homework, because every time I propose this to like an OPLA attorney, I did my homework. I sent them everything. I was upfront with them. I showed them the applications, everything that I prepared. So that way they could say, okay, it's worth it because I have something to show you rather than it be speculative. But I think it's going to be a case-by-case basis. But I would note this administration never said that PD is gone. They're just saying that PD is individualized now on a case-by-case basis.
They said that? I thought they said it was gone. I thought that was executive order number 1.
Priority memo.
Yeah, the priority memo is gone. They still could consider PD on a case-by-case basis.
Okay.
Like it's always been.
What are the offices saying, though, that you're working with? Because Charlotte and Atlanta are saying none. They are not doing PD at all.
Well, they don't want to give up their inherent authority, though. They're saying, hey, we have the authority to do anything because they want to dismiss. They could dismiss. whatever they want to do, because they might want to dismiss so they can expedite removal. So that inherent PD is in there. It's always an authority. I don't think it's something they want to give up totally, but it's just something that they choose in their discretion not to exercise.
And I think they would have significant legal questions if they outright did away with it completely. I mean, there would be serious problems with doing that. So they have to leave it at a minimum at that case-by-case basis.
I mean, the judges do it in the appropriate cases. T visa granted, dismissed. Like U visa granted, dismissed. Admin closure for sometimes some judges do only administrative closure for in the Charlotte, Atlanta court system for BDFs, bona fide determination. But
that's in their inherent authority based on the regs. Based on the regs, when you have prima facie cases and so on, that's their inherent authority. I mean, the stipulation authority, though, I think it differs a little bit because, again, if the judge exercises too much inherent authority under that on the regs, it could be troublesome. But
you're looking for a job.
But they have the authority now per regs. It's very clear to terminate in a lot of cases.
I agree with you, Annis. It's just Charlotte is overrun by Atlanta chief counsel, and he won't allow that. He won't allow OPLA to join in on that, the attorneys. So it's dependent upon the judge doing the right thing.
I mean, they're not exercising practically. They told us. I mean, I've asked. They said they're not really considering it. It's just that theoretically,
it could.
The possibility is still out there. They have the authority to decide whether or not they want to, exercise prosecutorial discretion.
True. And
the other thing you're right in the practical sense that they're just not doing it.
The other thing you need to be aware of in offices that have chief counsels that are saying, no, we're not joining in on this. We're not doing this. You can't just do it else you'll get charged with insubordination. So you just do what you're told. You can try to, explain to them and articulate. I did as a nice attorney. I did try to articulate valid and good reasons to dismiss a case or to administratively close a case. But at the end of the day, no matter how much you're trying to advocate for the right thing to do in the case, which is what our job really was, it's justice, it's not winning. You have to listen to what your boss says.
Always a creative way. I think
I love that.
That's why we got to be innovative. Because the way I look at it is, that person has a supervisor, just like our client is our boss, and we both have a certain way. Sometimes you're forced to kind of just go your own route and go as hard as you can. There's always a win-win situation somewhat somewhere if you be creative enough. Even where I'm thinking of, how they do because if a judge has the ability to pre-mit and DHS has the authority to pre-mit, make a motion to pre-mit an application, it could be something as simple as you make your application to pre-mit for approval grant and just ask the DHS counsel if they can not take a position or not respond.
I like that.
There you go.
That's where you kind
of. They're not violating their supervisor. They're not, because I don't want to put I don't want to put a DHS attorney in a bad spot with their supervisor as well. If I got to do it the hard way, through all the hearing and everything, that's no problem. I only ask for just fairness, good faith. What can you do? Is there anything creative that we can do? Can we stipulate to anything? Because at the same time, I'd love to hear this, is that, as the DHS attorney, you got to prepare for these too. I mean, you go through an individual hearing, the record's got to be clear, if you're going to make an appeal or not, and you don't want to have a bad record and then make an appeal. And so there's so many different issues that, when it's a clear case, maybe there's a creative way through a settlement conference or something just to get rid of it, because again, you have so much work. Everyone has so much work. Whatever we could do efficiently to get things done is great. Now, it will not work for every case, but there's a lot of cases out there where, there's some sort of compromise.
I would love you to bring cases to Charlotte and to Atlanta particularly and find out if you can do that creative stuff. Because if you can break through to Ryan and then maybe get a meeting with him, oh my God, you make things so much better, because he's just not like that. And I'll tell you, he doesn't give the attorneys there like, for example, when I was there, he said we couldn't join in anything. So you can't, and it's in the computer system. You know, they have a system called Planet. The notes are in there. A motion to pre-termit is in there. You have to put the line in there. You have to get the stats for that. It's all about these stats, like how many motions did the office get, and when did you apply? So they put in that. Then they have to put in their notes about how they responded or didn't respond. And if they're going to get in trouble on their performance review for not responding, I mean, all of that stuff they're going through, they're even going through it with AI now. So they will spot that. And if you're in an office that says you must oppose every single one of these, unless you come to me and get approval, and I'm going to approve basically almost none of them. That's Ryan Matsuno for you. All right.
Yeah.
He went into a Hyundai plant. He allowed them to go into a Hyundai plant where they had ballot visas. So just understand who you're dealing with there. But you're very fortunate. You really are, Ennis. You have a great office you're working in. Make me want to do cases in Buffalo.
You know what? I would be happy to do any cases, Charlotte. I don't know. I believe in the goodness of everyone. Everyone has their own thing. And if your rules are stricter and you're getting whatever the rules are, I play within the rules. And I look for understanding the other side's situation and what their reasoning and everything is. And it's our job to just crack the puzzle, whatever it is. It could be a situation of really pushing hard and fighting on removability or whatever you got to do, you know, but in a respectful way. I think there's no puzzle that can't be solved. And I always look at the other side. I think I learned from Nur and Rob and everyone. So it's good is just you respect the other side. And I never look to embarrass anybody or be mean to anybody or, you know, because we're all professionals. So just keep it professional. And I never take anything personal. If they got to say no, they got to say no. You know, I don't know what they're going through as well that caused them to say no, but I always ask. Worst case scenario, they say no respectfully. That's all.
With less judges and more cases, I mean, DHS is going to have to look for creative ways to solve things. Otherwise, it's just
they do
take over. So, all right, so that's it for tonight.
Can I just finish my little story?
Yeah, because I was just going to say that Susan had us started on a BIA issue.
Yeah, so the decision came about because I filed a mandamus asking for a motion to be ruled upon because it had been sitting there for since February. That was the third motion that I filed with the case that's on appeal for the underlying merits. Another attorney filed a notice to appear, Ben Schneider. Then I came into the case and never got an appeal briefing schedule. Neither him nor I. Case is still pending, like a lot of old cases. Never got a transcript. Okay, that I wasn't doing a mandamus based on the underlying appeal. I was doing it based on the last motion I filed, which is the third one, where we filed an I-751 waiver based on extreme cruelty. His ex-wife at that time was coming back and stalking him and his family. She even wrote something to me that was like, okay, this is disturbing. Like, she's getting mad at me because I represent him, even though she was cooperating previously, now saying that they're trying to get back together. They were living together again. And she thinks he's with someone else. So obviously a valid marriage. And then she starts stalking him. She's saying it in the text messages and emails to me. So I told him to take out a restraining order. He did. They couldn't find her to serve her. She also had bipolar disorder. So that was problematic during the marriage. But long story short, he got a notice in the mail, the I-751 waiver, saying that his green card or lawful permanent residence on a conditional basis is valid for another 48 months. And it's on a separate application. It is an I-751 waiver that is pending before USCIS. USCIS has exclusive original jurisdiction over that. BIA can't rule on that. I don't know who did this decision, but it was absolutely crazy. One, I did a motion to reconsider. There were procedural and factual errors that were substantive. The procedural errors, no briefing schedule, no transcript. They decided to rule on the and no appellate briefs from DHS or us because we didn't get those. They decided to rule on the underlying merits, order him removed, not just on the motion that the issue before the district court. And they also misstated the names of the motions. They called one an appeal. They cited it as an appeal. There was no appeal brief. They cited it as an appeal brief. They said I-751 waiver when it was a joint petition. They cited things incorrectly. They said there was no evidence that we provided. I gave them a copy of the I-797 notice of action, and I underlined it exactly where it said another 48 months. And that would be till 2029. So he's in status, and they ordered someone removed who's in status. And he's also eligible for naturalization. The only reason he wasn't naturalized was because the removal proceedings. So I filed a motion to terminate back in February 2025, asking to terminate the case based on the fact that he's in status. And I had put, additionally, he's eligible for naturalization. Now, DHS opposed the termination for naturalization. They can do that, obviously. And then this particular attorney, pretty personal for her because she did the underlying merits, and she had confirmation bias, if you ask me, based on my knowledge of the marriage and the case. Just so you know, honest, I took over after someone else did the underlying merits, but he's a very excellent attorney. His name is Ben Schneider. And
Can I ask a question?
Yeah.
So there was no problem with his status or anything. He was in status before an NTA was issued.
Yeah, he had his I-751 joint petition was denied because she walked out of the interview because she did this mental stuff. She didn't really want him to have status because she wanted to be able to control him. So because she knew she was a hot mess. She was mentally abusing him, and she was holding this status over his head, but I didn't know him at that time. And I would have told him to file, the 751 waiver then and stop going for it in the joint.
So was the denial failure to participate in the joint interview?
Nope. No. What happened is they had a second interview. The first officer wrote all these notes, basically citing things that were really bizarre, that basically she had Coach purses in her car. She had a report because they were stolen out of it. And for some reason, that means she must be being paid to be in the marriage. No, she bought her own Coach purses, and her husband bought her a Coach purse. They're not that expensive, by the way. You can go to Marshall's and get one for $80.
Did they issue a NOID or an RFE? Did they issue a notice of intent to deny or RFE?
Yeah, I think they did. Again, that was when Ben Schneider had it. And then
what was the basis?
But here's the thing. The second officer, I want to tell you this, Anna. The second officer who did it, they had to continue it. It went from the Charleston, South Carolina to Charlotte, North Carolina. The second officer who had it in Charlotte, North Carolina said, I believe you've explained everything. I'm going to ask for an approval. He goes to the supervisor. The supervisor wouldn't let him approve it. The supervisor went on the confirmation bias from the first officer. And Ben, that's what Ben would say too, because him and I had a lot of talks about this. He even said that when they got to the hearing, it was just the same confirmation bias. Christy Downs was the attorney. She's very strict.
So UCIS ultimately denied the I-751?
Yes, and that was in court for review of the I-751 joint petition.
So he wasn't in status so his status was terminated.
Well, no, they kept renewing it.
It's terminated.
Yes and no, but there were 751 waivers that went in that did separate 751 waivers. No, you're not. I will tell you, technically, the notice to appear, even if they take away that status, you have a right to a review in front of the immigration judge. You can't take away lawful permanent residence status on a conditional basis without first going through a review in immigration court. He's still in status. He kept getting stamps. And I know that very well because that's the way we consider it as DHS. You're still in status until you're ordered removed. And you even have the right to go to the BIA. Now,
but they had the right to take him to NTA him, I mean. So
they did. Right. Absolutely. Yeah, they had a right to NTM. It was
now you've got a final order from BIA.
A final from the BIA with no chance to ever appeal. Ever file an appeal brief. They wanted us to go to the Fourth Circuit. I talked to former immigration judge George Pop. He says, you do a motion to reconsider. You may still have to go to the Fourth Circuit. You highlight all the procedural errors because that's reversible error. You
That's the Fourth
highlight
Circuit.
all
Why not? But why not? Did they get a divorce?
Yeah, they got a divorce.
Okay, now the basis originally was a joint filing, right?
Yeah, and then he filed 751 waivers.
So they filed the waiver for the divorce.
Yeah, the first waiver that was filed was by Ben Schneider during
Has that been adjudicated?
No, the last one hasn't. But the first one, Ben Schneider filed while they were in court because she had it. She was done. They were showing up at her job.
Why not a motion to reopen and admin close pending the I-751? I feel like there's some kind of law or something out there that says
I'm doing a motion to reconsider first, and I've highlighted all. I'd love to send it to you guys and see what you think. It's already been filed.
But I think you should try a motion to reopen too, because would you have 90 days? Do you have?
No, I have 30 days for a motion to reconsider, and I got it in.
Yeah, but I think you got 90 days for a motion to reopen, right?
That's true, but there's a de facto stay of removal in effect with this motion to reconsider, and I'll do a TRO if I have to. But he has a document. He's in status. They cannot remove him. And if they want to, I've put some warnings in there. If they want to do that, I'm more than happy to file lawsuits on his behalf and win a lot of money for him.
But I think there might be an easier solution. If you can I think there's some case law out there or something that says when there's a pending I-751 that has some viability, that they have to continue the case. So maybe a motion to reopen.
It was at the board.
So yeah, motion to the board, and if they reopen and remand back to the immigration court.
That's what I was asking. I asked them to terminate it because he's in status, but I had prior motions to reopen, and I had prior motions to remand, 2 prior motions to remand. They ruled on that. Well, let me tell you what they did. They ruled on all 3 motions, did not give dates of when they were filed, did not discuss what they were about, lumped them all together, denied them all, and denied the appeal that we never got a transcript and briefing schedule.
That's difficult. I mean, that should be something that they.
And then Cersei was gone, and I'll tell you what she did too. I need you guys to know this stuff because it's good, honest, that you love everybody. I love that. Stay that way. You won't get retaliation. But I know her very well. And she immediately found any other board cases I had pending, and I had one other, and she immediately did the same thing. She had somebody I think it's a JAG officer, a JAG attorney, because they have no business doing anything to do with immigration law whatsoever. They didn't understand concepts. You can see it in this motion. In their decision. They lack immigration knowledge, and they actually cite it to. In the other case, he lives in the Fourth Circuit. He's been living in the Fourth Circuit. They cite all of their things are cited to the Second Circuit.
But I think
they're not reading the file. I get it. I can do that too. But I just filed. It's $1,000 now, and I paid that $1,000. It's a lot of money. This guy has spent a lot of money with me. So.
Yeah. And what I was saying is that regardless of with the adjudicators, because we're just going to have to deal with, JAG officers come in there. But even though they don't have an immigration knowledge.
I'm going after their bar annas when they mess up.
But I think something with a lot of these new JAG attorneys that are coming in, some of them might be very, very logical and common sense. They might not have the immigration knowledge yet. So it's just our job to kind of feel them out and do the homework for them and kind of advise them, write to them in a different way than you write to a judge, because they do have the authority to be appointed by the president and the way they're being authority.
They don't.
So,
that's actually wrong.
So
I'm sorry, and there's a USA. I worked for them. They got. You'll see. This is going to be a huge thing. It's just like during the time that what was his name? During the Bush administration, he did all these political hirings. It actually will come back to bite. These are USA jobs announcement. We all have the right to put in for these jobs. If you cannot appoint them. He fired people to basically appoint people that he could tell them, send them to military tribunals if they don't follow his orders. That's not the immigration court.
I understand. I think, the main solution, of course, would be if the immigration court was like a separate, separate from the DOJ. But, I totally hear you and I totally understand. You have so much more experience than I do than on that topic or so on. But I just look at it that, we're in a tough situation where we have clients that are in very difficult situations. Our appeal rights are kind of limited. Everything's expensive. There's only so much time. They have so much authority where they could, we got to find some creative ways or something to do, try to get to those approaches. And I know it seems naive, but the alternative of just filing all these lawsuits and
I have
like
a
that,
the Fourth Circuit's amazing. They will literally not that I want a precedent decision on this if we have to go there. They're not going to allow that. They're going to reverse themselves.
Yeah.
I'm telling you,
we need you to make that precedent.
I am.
News better.
But that's the end of my story. I'm just letting you know I'm fighting for my client. I'm zealously advocating, and we can't give up their rights. I know you're not. I know none of you are. You've got your creative solutions that are working, which is awesome. I have to do the fight, and unfortunately, this one person has been caught in the confirmation bias.
Well, and that's one thing that we have to be very aware of is everybody is extremely swamped right now. The judges, the DHS attorneys, us, everybody, and they're going to make mistakes. I mean, when you're as busy and everything is as backlogged as it is right now, people are going to make mistakes, and especially new military judges that don't even know all of our acronyms yet. So we have to be prepared to deal with those mistakes, either through litigation or through hopefully educating them beforehand and saying, hey, this is the rules.
Yeah, I agree. I just don't think they have any business being at the Board of Immigration Appeals. There are people unrepresented that are going to get decisions with the big warning letter that says leave right now or you're charged $1,000 a day. Up there, they need to be making the correct decisions based on the law. They should be experts in immigration law. I don't think there should be JAG attorneys writing decisions up there and board members who aren't even reading them, obviously, or they're not also educating immigration. And his file was like literally 2 feet high. It was clearly obvious they never read one bit of it.
I just, the only thing I'll say is that, with the JAG attorneys, you never know. Like I always like to not generalize, just keep it individualized. Only from this aspect is, you never know. I mean, they get put in a situation. They could be a very distinguished professional, very good at what they do. They just don't have that knowledge yet. And, at first it might be mistakes, so on, but we're in the situation we're in, right? And if we sometimes give them the benefit of doubt, maybe they're under a lot just jumping into something. We got to work with them. I say give everyone a chance. I don't know. I know
one last viewpoint is that I have a friend of the family that was JAG and also was with oil and then went to become an AUSA. And he's a Republican and he just stepped down because he was given illegal orders. So I do think if you want to keep your bar membership, there are people that they need to resign if they have to in protest because they want to keep your bar membership. If they can't do the decisions, I'm talking about the BIA, then they should step back. And
I totally respect that. I respect you so much. Everything is. I just get worried about the bar membership stuff because I think we feel it a lot on this side where we work our butts off and we try our best and we do such a great job. And you got Lozada hanging over you all the time. I feel like, I just worry about this, going after each other's bar license because it can go both ways. And what really needs to happen on that aspect, which is kind of unrelated, is Lozada needs to be taken care of. Like it needs to be ruled, it needs to be taken care of. And I think there should be a mutual respect between the all attorneys that think about it this way. You could be an amazing attorney and you get 1,000 cases done perfectly. You just have one bad day or one bad mistake and you lose your bar license and get a bar charge.
No. That's not what I'm trying to
do. Not in you. I'm saying for us. That pressure.
I get it. It's scary to be on this side. I never had a bar complaint in my life.
And that's, I think, one of the things that I just, as a word, that's definitely something we got to bring in is that, I think this whole Lozada issue, and I just worry about trying to do the cutting edge because the way we feel from it is it gets us really, very defensive, very worried and stuff like that. And I just worry that even because you have these great arguments about it's illegal order or you're not supposed to be doing it or so on. I just worry about that issue being a little pushed because then you could get the blowback where it's like fair game for everyone. I just worry.
Okay, I get
it's
that,
it's
but
not a system that promotes collaboration,
Yes.
to resolve things. It just doesn't.
It
I
does.
get that, but let's say they continue to, I've taught them the law, I've put it in there, and whoever writes this decision is forced to write a decision. Let's say they told you, Annis, and you knew the law was opposite of what they're telling you, but they're telling you this is what you're writing. Okay,
You're right. No, you're right.
I think they have an obligation. I'm just like, if they were to tell me that, and I work for OPLA right now, I'd have a big problem with this whole EWE thing and mandatory detention. Now, I'd have to really look at their argument, but I don't think they're correct. And there's so much precedent on that. And I would have to say, I respectfully can't do these cases because I have a bar membership to uphold. That might get me fired, but I did the right thing.
I think the solution somewhat for if there's repeated problems like this is probably more of a class action where you can get into a settlement in federal court,
That's a
get
good
a
idea.
class action notice, and then they, reopen all these cases pursuant to a litigation settlement.
I like
Show
that.
better stuff.
Much
Because
better.
if you look at it, DHS has been willing to settle litigations in certain aspects, put in a notice. Like remember the 1 year filing? Was it
Yep.
Meja Rojas or not? I think that's the way to do it, rather than I just worry about the.
No,
the problem is-
I love that, Annis. There you are.
That
with your
way,
solutions.
that way, even us as attorneys, we're kind of shielded a little bit if there's a way that it's brought in the right way.
Right.
Because it's like, like Susan, why do you have to be the one to put in the stuff and then have all the blowback back on you
Right.
to be like, oh, that's the attorney that's suing everybody, and you will not get a decision from anyone. You'll get denied on discretion every time.
Right.
So I think it's more planning and collaborating and seeing how we can get into a settlement conference or something like that with a class action of a team of attorneys. So that way we're all kind of like.
Or maybe Ayla files it because then it's just, or whomever, one of those groups.
Amicus briefs
Right.
or whatnot. And you get to that point, I think that's our approach. We collaborate as much as we can if the problems are, because if we try to litigate up through the circuits of the Supreme Court, that's too costly. That's too time intensive. And you don't have an automatic stay at the circuit. You could be deported before it. So I think really what it is a network developing where if we see a matter of patterns or so on, that you get together and you do a class action so you can force a settlement. The class action is not necessarily going to win on the merits, maybe, and it might not go to trial, but it might be enough for DHS to be like, okay, yeah, this is obviously egregious. Listen, we don't want to admit liability. You don't admit liability. We'll just do this class action where we open your cases as a class, limited to this class settlement. And a lot of times people are asking for attorney's fees or money. No, you don't need the money. We need to fix our clients' lives because that's more important than the attorney fees or the money or restitution.
Exactly.
We don't need any of that. We need the immigration relief.
I mean, this
So
guy's
I think
entire
that's-
family are U.S.
Because
citizens.
the federal courts have been receptive a little bit to, at least for some federal district court stuff, they've been a little bit receptive to pushing back.
I think
And
they
that's
will.
the way you can get in. That's the way you can get in rather than trying to get review of the motion or the appeal because there's no procedural mechanism to get there to the district court.
This one is in the District of Massachusetts, and they're very receptive. And I think that they will. You guys are both. Oh, I thought you were both frozen. You both looked down at the same time. So I think they'll be receptive to my motion to reconsider and probably push back. And I also sent a copy to OPAL headquarters because I just want this guy to get what he's entitled to. But I like this. I like the class action. Thank you for the idea, Annis. I think it's great if you guys start getting decisions that come back that seem just like they're written by people who don't know what they're doing. I think eventually if people are getting these decisions left and right from different attorneys, that would be a great thing, a class action.
Like a class action or something like that. Or again, just, individual basis. I think, we attack on the law. We don't, we attack on the law. We do class actions, but we try our best to figure something out. Now, there's not always a solution, of course. Sometimes it doesn't work and so on. But I just think that, You never know. It might be a situation where someone, because there's a lot of immigration judges that know a lot of immigration law, but they'll never give you a grant and they'll never
True.
give you a SIP.
True.
Whereas, at least in this situation, you got someone coming in new, you got maybe a chance, but you're going to have to approach in a different way. It's not going to be as legally technical, and you're going to argue more. What do they say? If you don't have the law, argue the facts. If you don't have the facts, argue the law, right?
Right. Don't pound the table.
Don't pound the table. It's just an opportunity for us to be innovative and everything till 2028 when it all changes again.
And I haven't filed anything against anyone. It was just a thought. But
no, not
I like that you have given me the better idea. Thank you.
Absolutely. I really think it is, because I think that if our energy is based on creativity, and like I always think about the other side, and I just say, how can I solve their problem so they can look good in front of their supervisor and I can look good for my client, if it's possible? Because we have our ethical and professional responsibilities forever. But, I found a lot of opportunities where there was ways for both of us to look good and both of us to comply with our ethical, legal, professional obligations. And, this one wins. Like in every 237H waiver, you get if you as an DHS attorney, if you get your removability finding, you got your removability finding, right? And if you just happen to have relief and the judge granted discretion and you never took a position, it's not your fault. You're fine. The supervisor hopefully won't pound you too hard on that one because you got the removability finding. But if you lose on removability right on the bat and the case gets terminated, I'm sure that doesn't look good for a DHS attorney, right? To get it terminated on the merits, on removability. So, we all got to work together, and everyone's overloaded. And maybe one day somebody might have the advantage, but the next day you might. So I never take advantage when I have the advantage, because tables will turn pretty quick.
Actually, just let you know, it doesn't look bad if you lose a case on removability, because that means that the case law, that means that there was no removability. The way I look at it, I don't think it would have to be, again, a certain supervisor that would be mad. That shouldn't be.
I had cases where people didn't even file an I-213 or whatever. Didn't even file any evidence or nothing. And that's an opportunity to work with them because,
Oh, yeah, I would definitely work than be embarrassed.
All right, guys. Well, getting late.
Thank you. Thank you all for
all right.
Everything.
We'll see you at the next one.
Yes. And Annis, keep coming up with those ideas. I love it.
I'm trying. I'm just trying to get this app done. This is my AI app. Then we'll go from there.
Well, I can't wait.
It's going to be awesome.
Thank you, guys.
We'll see you.
Bye.
Bye. Bye.